Thank you for joining today's Law with Lunch. My name's Lydia Reid, and I'm a barrister at Park Lane Plowden and part of the employment team. Today, we're going to talk about reasonable adjustments and how to navigate those claims in the employment tribunal. So I'll start with the legal framework and getting back to basics. And then we'll zoom in and look at the specific component parts of a reasonable adjustments claim and finish by looking at the practical steps that both claimant and respondent practitioners can take. So the reason really that I chose this topic today is because of the National Employment Tribunal User Group meeting minutes. This isn't something I spend a lot of my spare time reading, but I'm sure many of you are subscribed to Daniel Barnett's mailing list, and he recently sent out a summary of these statistics, which I went to have a look at. And what's interesting is that disability discrimination makes up now for over half of all discrimination claims in the employment tribunal. The statistics are for 2025 to 2026 are not yet complete, but from the statistics we do have so far from the first quarter to quarter three, there are 9,175 cases of disability discrimination. Compare that to then the second and third place, as it were, with race discrimination claims coming in at 4,099 and sex discrimination claims just below that at 3,460. So the trend really seems to be, well, two things: that discrimination claims are on the up, and that the disability discrimination claims are on the up, and that disability is the most litigated protected characteristic. The reasons for that aren't quite clear. It might be an increase in AI assisting particularly litigants in person, but either way, it's certainly claims that a topic rather that requires looking at in more detail. With that in mind, then, going back to our bread and butter, it is the legal framework. The statutes, the relevant parts of the statute are on the slide. Section 6 is the disability definition. So a person has a disability if they have a physical or mental impairment that has a substantial and long-term adverse impact on their normal day-to-day activities. The relevant then parts of the Equality Act for reasonable adjustments are Section 20, so the duty itself, and Section 21 being the failure to comply with the duty. Section 20 has three requirements. So it's not just, as often in practice, it appears to be the provision, criteria or practice that puts a disabled person at a substantial disadvantage compared to non-disabled people to take reasonable steps to avoid that disadvantage. But it's also a physical feature and, of course, the provision of an auxiliary aid. Then the Section 21 is clear that if an employer fails to comply with that duty, that is seen to be discrimination against a disabled person. The case law on disability discrimination and reasonable adjustments is relatively well settled, but this case, Mallon and ACOM, was, in my view, quite helpful as a reminder not to forget the other two parts of Section 20. So His Honour Judge Taylor explained that often the duty to make reasonable adjustments is analysed to be focusing on the first requirement, so PCPs. And he goes on to say at paragraph 27, so on the slide here, that no consideration in this particular case was given to whether the claimant needed an auxiliary aid. And the third requirement, as it were, should have been borne in mind. This case is also helpful because it reminds us when looking at who bears the responsibility of a reasonable adjustment, it falls on the employer or the prospective employer. It's not enough if friends and family are prepared to help, and the expectation isn't on them, it's on the employer. So it's a helpful reminder to us that whilst we were probably most familiar in practice looking at PCPs, the other two parts of Section 20 might be relevant and might better assist cases that we face. The second case that is relevant is there's a note there, is the case of Morgan, and that's helpful because it reminds us that the duty arises when a disabled person is at a substantial disadvantage by a PCP physical feature or not providing an auxiliary aid. The duty to comply begins as soon as the employer can take reasonable steps, and the scope of that duty is confined to job-related matters. So the now zooming in really, as we've got the basics and reminded ourselves of the statute, to the burden of proof. Initially, the burden is on the claimant, and it's on them to identify the PCP, the substantial disadvantage, and crucially, the adjustment. Then the burden shifts and is on the respondent to then show potentially, or to show whether the reasonable adjustment that's been identified is potentially reasonable or not. The rationale behind that is that the claimant must really give an indication to the respondent of what requirements or adjustments that should be made. That allows the respondent to know what case it's meeting and can then enable a respondent to dispute whether an adjustment is in fact reasonable in the circumstances. On the slide there, I've put the case of Project Management Institute and Latif, and that's an important reminder for us about the burden of proof. It's clarified, and I certainly won't read it out, but the president of the Employment Tribunal, President Elias at the time, explained that the employee is to put forward that adjustment. That's not to say that the adjustment should have been put forward at the time that the claimant is complaining about. The proposed adjustment can be identified after the alleged failure to implement it, and it can be raised by the tribunal itself. But the respondent needs the starting block from the claimant to then show the steps that they have taken to remove that disadvantage. So the key question really is whether the adjustment identified by the tribunal or the claimant was a reasonable one. It's also good to know that even if an adjustment is not suggested by the claimant before the hearing, the tribunal can still consider it. We'll come on to that later. Provided that physical features or auxiliary aids are not in dispute, and knowing really that PCPs are often the main part of Section 20 for reasonable adjustments claims. It's helpful to look at the PCP in detail. The PCP is the first link in the chain of a Section 20 claim. The tribunal must identify the relevant PCP before considering the nature and the extent of the substantial disadvantage suffered by the claimant. So spend some time, either if you're for the claimant, considering is it a provision, criterion or practice, and if for respondent, looking at what the claimant might suggest they are, and analysing it critically. The case law says that a practice is something that has a sense of repetition. So if it's just a bold assertion from the claimant, spend time considering and questioning whether it really is any of the provision, criterion or practice. The PCP itself is a base position before any adjustments are made. That I think is easy to forget, because it's a reasonable adjustments claim is presented in the context of the PCP as well as a substantial disadvantage flowing from that. But essentially it's neutral, and it's something that applies to everyone without the adjustments in place. While it's neutral, the PCP, when it's formulated, shouldn't be so general that it's not relevant to the claim. It should really get to the heart of how a disabled worker might be disadvantaged by the application of that PCP. So it's the starting point, but it needs to be neutral, and it needs to be sufficiently specific to assist the tribunal when considering the remaining component parts. It really, though, is a feeder for then the rest of the reasonable adjustments claim. The steps that, when reaching the end of the claim, the reasonable adjustments that the employer may or may not have taken will depend on the particular PCP. And so that general approach isn't going to necessarily assist a respondent if it is taken from a too general view. The EAT have cautioned against reverse engineering the PCP. So I'm sure all of you will be familiar in case management hearings. If faced with a situation where the PCP isn't quite clearly constructed, it is tempting to look at the information that's on the page in the ET1 form. However, the case of Ahmed, which is over on this slide, served as a reminder to not take the PCP from the substantial disadvantage. The risk is, and I certainly have seen it in practice, for things to become circular. So if the substantial disadvantage is taken as your starting point, and working backwards to try and find a PCP that doesn't quite neatly fit, it risks the claim becoming circular. That certainly for the claimant is not a helpful approach, and runs the risk of really the claim failing. Looking next then to the substantial disadvantage, the definition for substantial from section 2 of the Equality Act is more than minor or trivial. And by considering the the guidance really is to identify and consider the actual functional effects of the disability. What does that really mean? Well, I think that's looking at 2 parts and separating out the disability from the disadvantage. Looking at the nature and the extent of the disadvantage is key, so weighing up whether it aligns neatly with the PCP is helpful, but also I think it's important to ask yourselves, is it more than minor or trivial? How does it affect, or how is it alleged to have affected the claimant? And what are the facts from the claimant's actual disability compared to the assumptions or what a claimant might say are the effects of their disability? So in doing that, the information likely to hand at this stage will be the claimant's medical records from their disclosure about their disability. So critically analyse and take stock of the disability and the symptoms alleged, say, in the medical records and the disability impact statement, and assess really, does it line up with the suggested substantial disadvantage? The tribunal will judge the position on the true facts rather than what parties believe. So if a respondent is allegedly in breach based on a belief about either the disability itself or the substantial disadvantage, and that transpires in final hearing to not be the case, then the case will be judged on the true position. So if the claimant is not placed at that substantial disadvantage, then the employer will not be subject to the duty. When looking at both the substantial disadvantage and the PCP in tandem, the question really is whether the claimant has suffered disadvantage in light of that particular PCP. So it's not enough that the claimant might be saying that they suffer from a disadvantage. It needs to be substantial, so meeting that more than minor or trivial test, and it needs to be particular to the PCP alleged. So all flowing really neatly as links in that chain. Knowledge is really crucial to a reasonable adjustments claim. It's important from a respondent's point of view, because if you don't have knowledge, it can be a complete defence to the claim. The question on the slide is often one that will appear in the list of issues, and it really adopts the wording from paragraph 21B in Schedule 8 of the Equality Act. And that says that even where an employer knows that an employee has a disability, it will not be liable for a failure to make adjustments if it does not know or could not reasonably be expected to know that a PCP, a physical feature, or a failure to provide an auxiliary aid would be likely to place that employee at a substantial disadvantage. So I think the situation probably can vary depending on what the disability may be, and then what the employer knows. It might be a situation where the employer doesn't know anything, so they don't know that the claimant, the employee, has a disability at all. But it also could be more nuanced, that they knew that the claimant, the employee, had the disability, but did not know that the PCP was placing them at a substantial disadvantage. That could present a bit of a tricky scenario for an employer, because the burden on the employer is to make reasonable inquiries. So the expectation isn't to make every possible inquiry, but the employer should, based on the information provided by the claimant, make reasonable inquiries as to that substantial disadvantage. It's not reasonable, or it's unlikely to be reasonable, if an employer knew about a disability and then just buried their head in the sand. The reason that the burden's on the employer to make those reasonable inquiries is to essentially allow them to step up and investigate whether there's likely to be any problems for those disabled employees. So knowledge is certainly one to consider if you're defending the claim, but carefully clarifying your position as to what is known and the extent of that knowledge is key, so that when if the situation is in final hearing and a witness is being asked about what they knew and then what they reasonably could have done afterwards, that you're not in sticky waters. Looking then to what is reasonable, so as the reasonable adjustment stage of the claim. This really is a limit on the duty. It means that employers, when responding to these claims, can avoid liability if the proposed step is not reasonable. When looking about what does really reasonable mean, the answer seems to be found in Article 5 of the EU Equal Treatment Framework Directive. That reminds us there on the slide that there is no duty to take measures that would impose a disproportionate burden on the employer. So reasonableness is as with other areas in the Equality Act, linked with proportionality. The test is an objective one. So the tribunal, in making a decision, will look at the adjustment from the respondent's point of view, look at the adjustment from the claimant's point of view, and then make an objective determination as to whether the proposed adjustment is reasonable, is a reasonable step to make. So they must consider both parties' perspectives and weigh up that decision. Unlike unfair dismissal, the tribunal is essentially substituting its own view and stepping in there for that of the employer. It may be that there's a certain set of facts that mean that multiple adjustments can work together to alleviate one substantial disadvantage. In that scenario, the tribunal will look holistically at how the adjustments are in practice, and really answering that question of whether it effectively alleviates the substantial disadvantage. But on the other side of the coin, there might be situations where no adjustment will be appropriate. For example, in highly regulated areas, it might be that no adjustment is possible if there are external regulatory obligations, or if there's a hospital scenario that require and an employee is, say, wanting to work part-time, but there is a necessary number of employees required, say, on the ground, that might not be possible, and the tribunal may find that is a reasonable approach, obviously fact depending and employer depending. The objective test, so the employment tribunal stepping into both parties' shoes, means that the tribunal can make a finding for a different adjustment to the one that was pleaded. So where the disadvantage is reduced, the employment tribunal might find that a different adjustment would have been reasonable. That remains the case even if the claimant does not prefer that other step. If the tribunal find it to be reasonable and it hasn't been taken, then that is within their remit of the objective test. So the Equality Act doesn't, unfortunately, provide us with a list of factors when we're considering reasonableness and proportionality, but Section 18, 18B of the DDA and the ECHR Code of Practice at paragraph 6.28 provides a list of matters that can be considered. In just running through those, you can really get a sense of the holistic view that's taken. So the tribunal will consider the extent to which taking the step would prevent the substantial disadvantage, so how effective really that step is, the extent that it was practicable for the employer to take that step, the financial and other costs incurred by the employer taking that step, and the extent that it would disrupt their activities, so the employer's activities, the employer's financial and other resources, the availability to the employer of financial or other assistance in taking that step, the nature of the employer's activities, so that comes into the previous example. If for whatever reason you're a highly regulated employer and the adjustment is not appropriate, that will be considered, and the size of the employer as well. So the focus with the proposed reasonable adjustment in the claim is a practical one, and it's practical on two bases: the practical outcome, so the effectiveness of the step in practice, and then also practicalities for the employer, really. How easy is it for the employer to take that step? To me, it seems this is where claims can be won and lost. It's important, whether claiming or defending, to be objective and put yourself in the employment tribunal's shoes, but there's ample scope to argue one way or another about what the steps, whether the proposed step is firstly appropriate in terms of alleviating the substantial disadvantage, secondly reasonable in practice, and then thirdly reasonable taking into account all of those additional factors, so reasonable for the employer and whatnot. So it's certainly, whilst it falls to the end really of a reasonable adjustments claim in the statute, it is really one to put significant emphasis on. Looking now think my video just turned off, but hopefully it's back on now. Looking now at practicalities and how reasonable adjustment claims work in practice, I'll start with approaching claims from a claimant's perspective. And really, the most helpful to both the claimant and the tribunal is to be precise. And that is, I think, flows throughout the whole, or each component of the claim. So being precise with the PCP, if applicable, or alternatively the physical feature or failure to provide an auxiliary aid, and the substantial disadvantage, and then the adjustment. So that pipeline should really flow from start to finish. It will, and we'll cover the list of issues shortly, but having the list of issues in mind it really facilitates that task. Breaking each part of the claim down to provide the information that the tribunal will require to make a final decision of it when determined at final hearing. If there are multiple PCPs, consider whether there is more than one substantial disadvantage, and if there's more than one adjustment, or ask, is it possible to be mopped up altogether? Does it have one effect rather than two? And is that effect perhaps a cumulative one because of both of the PCPs working together? So be precise about how then that will make your claim look when construing it in your pleadings or in the list of issues. Identifying the PCP and then the consequences of that with precision is really helpful. So thinking through, if this is my neutral baseline PCP, how then does that affect the employee, and how can that then be alleviated with a reasonable adjustment? So bearing in mind the consequences of how you really construct it from an early stage, it is important to help your claim succeed. There might also be a claimant who has more than one disability. So it might be anxiety and depression, and they both might have the same, they might both come into the reasonable adjustments claim. But it also might be something completely different. So there might be a mental impairment and a physical impairment, but the mental impairment might be the relevant disability for the reasonable adjustments claim. So take stock and take instructions, of course, as to whether it is all or any disabilities for the reasonable adjustments claim, or if there is another disability claim with something separate, whether it's not relevant. Ultimately, it's not a case of everything going in for the sake of it. It's assessing and analysing how that particular disability has come into the reasonable adjustments claim. As well as more than one disability, there might be more than one disability claim. And the cases I've put on the slide are helpful because the first one, Muzi Mabasso, indicated and discussed the crossover with indirect discrimination claims and reasonable adjustments claims. In that case, the tribunal at first instance rejected both the indirect discrimination claims and the Section 20, so reasonable adjustments claims. Then on appeal, the tribunal, it was found at first instance, failed to engage in the balancing exercise for determining justification for the indirect discrimination claim. So that was remitted back. On the reasonable adjustments claim, Her Honour Judge Eady looked at the findings on disadvantage. The first instance tribunal accepted that the PCP for the indirect discrimination claim did put the claimant at a particular disadvantage. However, on the reasonable adjustments claim, which used the same PCP, they concluded that no substantial disadvantage was made out. So, and in that case, it was the same evidence and the same PCP, but for the particular disadvantage, it was met, but for substantial, it wasn't. So be mindful of the crossovers in indirect discrimination claims for, firstly, PCPs, secondly, the disadvantage. Particular and substantial are different tests, but there's inevitably going to be crossover in the analysis that we've spoken about, looking at the disability and how that affects the employee. And then finally, the crossover is likely to be in the evidence. If you're working from the same timeline with the same witnesses, then don't take them in isolation, look at them together to assist you. Secondly, the case of Griffiths discussed the crossover with Section 15 claims, so discrimination arising from disability. And Lord Justice Elias explained that an employee could be dismissed without a reasonable adjustment being made, and the two claims could run at the same time. So his example was part-time work, and he explained that then may be a breach of the duty to make reasonable adjustments if part-time work, as the reasonable adjustment was refused, and then the dismissal was likely to be unfavourable treatment for the Section 15 claim. So they certainly can run together. The ECHR Employment Code as well gives some further guidance there on the slide at paragraph 5.21. It may essentially, if you're running the objective justification defence in Section 15, it may be even harder to establish if you fail to make reasonable adjustments, given that you're looking both at reasonableness and proportionality. So they're likely to be interlinked, and it's important to spend time carefully crafting how those claims will run together to succeed. If, though, you're for the respondent, there's a few different things to consider. That said, though, for both parties, using and looking at the case from the other side's point of view is inevitably going to help you, and it's inevitably going to help you by considering, well, if the claimant's coming from this side, what can we anticipate from the other? And for respondents, really, it's helpful to get a specific kind of construction from the claimant as possible. Dates and people are your friend here for three main reasons. You get clarity in defending the claim, and you know what claim you're trying to meet. When answering the when question, so when the respondent could have reasonably made the adjustment, it can help you in terms of assessing time limits and narrow down the issues if the claim is significantly out of time, and it helps you with disclosure. So the questions there are on the slide. going to assist in narrowing down how the claim will look. But be mindful of requesting further and better particulars. I suggest setting out what's missing in the list of issues instead, and we'll discuss the list of issues in the next slide. The knowledge defence we've already touched on, that being knowledge that the employee was disabled and likely to be placed at a substantial disadvantage by way of the PCP physical feature or lack of the auxiliary aid. So be mindful, though, of the constructive knowledge of what employers could be reasonably expected to know, and ensure that if there are inquiries made, and the respondent's case is that reasonable inquiries were made, evidence that, and make sure that is crystal clear, because it could quite easily be the difference between you winning or losing the claim. And then finally, the wording and the construction really of the PCPs. I'm sure we've all been there where the PCP wording is not quite clear and doesn't neatly fit with the rest of the claim. It's, for a respondent, possible to use this to your advantage. If you have a go in your grounds of resistance at trying to put together what the claimant's getting at, then that might enable you then to succeed when the claim then comes to fruition. The judge will certainly at case management stage be grateful for you having a go either in the grounds of resistance or the draft list of issues, rather than it being an erroneous task in the case management hearing. But if you essentially get the first draft at what the PCP might be, that's likely to help you, because it's probably possible that the claimant's substantial disadvantage and suggested adjustment won't all fit neatly. And as we've discussed, that's really key for a successful reasonable adjustments claim. The second point on PCPs is to confirm your position, if you can, in your grounds of resistance. So if it's accepted that there was the PCP alleged, then do say so. If the wording's similar but not quite as you should think, also raise that in your grounds of resistance. The tribunal will be grateful for the narrowing of the issues, and ultimately not everything needs to be in dispute. If it's agreed, then that assists everyone. Looking then to the list of issues, as with any claim, I recommend sticking to the statutory wording. No doubt you'll all be familiar that the list of issues is a roadmap for the final hearing, and it's rare for it to be departed from. So that really means it needs to be, you need to make it count and make it benefit you where possible. As I've said with the claimant, from a claimant's approach, if there's more than one disability, identify which is the relevant disabilities, or which are the relevant disabilities for the reasonable adjustments claim. And then the statutory wording will flow and break it down often into around 8 questions. So, for example, and this is one I've drafted on a hypothetical situation, the relevant disability is in this claim agoraphobia only? Did the respondent know, or ought it reasonably to have known, that the claimant had that disability? Did the respondent have the following PCP? So a requirement for employees in the claimant's role to work in person, so come into the office. And did that PCP put the claimant at a substantial disadvantage compared to someone without that disability, in that she could not leave the house? Did the respondent know, or could it reasonably have been expected to know, that the claimant was likely to be placed at that substantial disadvantage? And what steps could have been taken to avoid the disadvantage? And the claimant suggests permitting home working. So that's where the claimant can put in, and indeed has the burden to suggest that step. And then the final two questions that are taken are, well, two in one for, was it reasonable for the claimant to have taken those steps, and when? And did the respondent fail to take those steps? So that will be they will be the issues that the tribunal will consider when you get to final hearing, and have those in mind when taking stock of the evidence, and certainly for both parties in responding to those claims. If you're for a claimant and you've noticed really that things don't fit together as neatly as like a satisfying jigsaw puzzle, then you might be in some difficulty. If you're for the respondent and the suggestion for the reasonable adjustment is so far from reasonable, then you might be successful. You might get home on that, but you have to bear in mind, as we've discussed, that the tribunal might, in their objective test, find a different adjustment as well. So just before we finish up, a few tactics that both parties might benefit from. Looking, as we've discussed with the previous slide, about further and better particulars, it's certainly a tricky one, and it will depend on what information you have and how best you can work with it. But it might be better to let it ride rather than requesting those further and better particulars. For example, you might really need better particulars, and certainly you probably don't want further particulars. So consider how you're framing that request. If you have a draft list of issues, say a week before the case management hearing, and you're just trying to fill in a few gaps, so for example the when question, it might be far easier to highlight that and send it to the claimant than to then receive, more likely than not, several more pages of information and potentially with the assistance of ChatGPT. The most relevant point here in tactics is disability preliminary hearings and their benefit. It has the potential to really limit claims. So take a step back and look at your remaining claims. But if you're for a respondent and you have that maybe one claim remaining that isn't disability related, it's likely going to be more beneficial from a cost point of view to list the one-day PH and attend than the final hearing going ahead. If you're successful, you could then be faced, instead of a 4 or 5 day final hearing on disability discrimination and one other, you could be down to a 1 or 2 day final hearing, which is certainly favourable from a cost point of view. It could be that the respondent takes an approach of listing at case management stage, a preliminary hearing, and then vacating it. So asking for the evidence, the disability impact statement and the medical records, and once you're in receipt of those, taking a view on the evidence. Is it contested? Is it not? And if not, vacating the hearing. And I say that because really, with the delays in the employment tribunal at the moment, it's better to have it in your as one of your directions, and then not need it, rather than having to wait who knows how long for a one-day PH. Same applies as well with the time limits PH. Obviously less common, but helpful, I think, when the when question is answered. That might place it out of time, but it might equally be more proportionate to deal with the other issues in final hearing. As we've mentioned and discussed, the crossover between discrimination arising and indirect discrimination claims with reasonable adjustments. The evidence, both witness evidence and documentary evidence, will hopefully enable parties to kill two birds with one stone and make disclosure somewhat easier. And then finally, assess the merits of each statutory question. So if you're doing a merits assessment or advising a client, both employer and employee, take stock of each and every part of the statute, because there's ample opportunity for a claim to succeed or fail, and I say more probably fail if one of those part of the steps that we've mentioned are not met. The case of Rowan on the slide there zoomed in on really the substantial disadvantage part. So identifying and looking at the nature and extent of the disadvantage was key, and then the employment tribunal will assess whether the duty applies and what adjustments are reasonable. So taking a view holistically is helpful, but zooming in, as we have done today, on each component part will certainly be beneficial in the long run. So that concludes my talk and everything I wanted to say on reasonable adjustments.